Rob Saccone, how are you?
Doing well, Ted. How you doing?
Good, man. This episode is long overdue.
Yes, sir.
We,
Yes, sir.
you and I have known each other for probably 15 years. We
Oof.
shared a similar, I guess, kind of product path journey. You were kind of the beginning of the legal intranet movement and handed it off to Handshake, which handed it off to us. And yeah, so you and I have been kept in touch over the years and worked together. So man, it's good to finally have you on.
Yeah, I'm excited for this. Yeah, longtime listener,
Yeah,
first time caller. So yeah,
good
let's
deal.
do it.
So for those that don't know you, I mentioned you were a product company CEO with XM Law, but why don't you kind of fill in the gaps, like what what are you doing now? What got you into legal? How long you been here? All that sort of good stuff.
Sure, sure. Well, in a nutshell, it's been a little over 26 years, dare I say out loud, that I've been at the often messy intersection of business tech and law, right? And I've worn a lot of hats during that time. Actually started as a self-taught software engineer and just worked my way into building enterprise systems in a few different verticals until I kind of stumbled into the legal market back in 1999 when I joined Goodwin to help them build out their relatively new KM function. Um, didn't take me very long to see that there were plenty of opportunities in legal service at the high end to bring business tech, lots of things that I was comfortable with that were kind of foreign to firms at the time, it seemed to me. So it didn't take me, I don't know, maybe 2002 or three. I leapt headfirst into entrepreneurship and started XM Law back before we called them legal tech startups, I think. And built that company out, did a lot of really fun, awesome work, and sold to Thomson in 2009. I stayed with them for a few years in a couple of different roles in product and strategy until I felt the itch to get back to startups and small teams, small organizations. So I shifted back into startup work, this time doing a little more investing, advising, like broad range things, but continued working with law firms at the time when internal startup efforts were kind of nascent. You know, innovation teams and roles were still forming. ALSPs were gaining a lot of attention. So there was a lot of like hustle in the market to like go after this, you know, new form of legal service delivery. Um, and that fortunately for me led me to the leadership team at Skyfarth. And Steve Poor, Lisa Damon, and others had been fighting the innovation fight for years before I showed up there. You know, so they were well ahead of the curve. And I designed and built a subsidiary of the business called Seyfarth Lean Consulting, where we served our clients and even non-clients directly with legal ops and analytics and service design and so on. Um, since then, I've done a whole range of different random projects and work with a lot of cool startups and legal tech companies, including Infodash,
Yeah.
and even took a break as an operating partner in private equity for a little over a year. You know, so that was my one escape from legal, I guess. But then ChatGPT appeared in the world in 2022, and like many of us, I jumped on the AI train. I was able to work with a few firms on very early, like some of the first pilot projects with products like CoCounsel, and worked with Jake and his team to sort of bring it and get feedback from a lot of big practitioners. And that brought me to where I am today, fully back into startup mode as CTO here at Lega. And my day job now is putting Gen AI to the test and helping firms figure out practical, safe ways to use it. So yeah, I've been really fortunate to work with a lot of very smart people and teams over the years, and it's definitely made me opinionated on how things work and how innovation can and can't work. So can't wait to dig in.
Yeah, man. Well, your experience with Seyfarth Lean, and for those that don't know, you were on our first iteration of an advisory board. I think we were too early, really, to make that work, and then like one board member got a job, and it just like it kind of fell apart. We're reestablishing that very slowly and intentionally, but yeah, we really you had a lot of very valuable input for us in the early days. So we were happy to work with you. Your work at Seyfarth was especially interesting in the conversation that we're about to have, which I think is super relevant right now, which is, the alternative business structure. You and I were bantering back and forth on a post about Burford Capital standing up managed services organizations, MSOs, as a vehicle to get outside capital into law firms, which is prohibited by ABA Model Rule 5.4 in every state except two, with the addition of DC and Puerto Rico. And we were kind of kicking it back and forth on, hey, will it work this time? And we had some different viewpoints. I think that the earlier attempts failed for interesting reasons that I think exist to a much lesser extent today, and that the innovation around Gen AI, a language. I mean, when have we seen a disruption in how language gets processed? It's been, this is really the first major disruptive tech, which is has so much relevance to how lawyers work. So I think the timing is right. I think we're starting to see, the Legal Services Act in the UK has been around for 15 years now, almost. Maybe even a little bit longer. And so we've got a model to look at, and that it hasn't really moved the dial a whole lot over there, but I think that it also hasn't caused a ton of issues that so many lawyers have presented as why you need Rule 5.4, and making non-legal ownership prohibited. So yeah, man, let's talk a little bit about Seyfarth Lean. I'm a Lean Six Sigma black belt. I got trained at Bank of America, and it is a rigorous training. I mean, I think I went through a month of training, and first you get your green belt. So the way it works there, I assume there's similar thresholds at other places. You have to save the bank $250K or generate $250K in new revenue to get your green belt. Then the threshold is $1 million, and those have to be
Interesting.
yeah. So when I saw Seyfarth Lean, I was like, man, is this a Lean Six Sigma kind of approach to, or lens that you're taking to legal services, which I thought was interesting. But yeah, like how did and does Seyfarth Lean, are they still around?
It does in a different form, right?
Mm.
I think it's more integral to the firm's practice now. It's not a standalone business with its own P&L, and the other reasons which we chose to explore that, I guess. But there a lot has been written about this in the world. Like, you can find it online, and it's a fascinating story. I showed up at a time, oh God, I can't remember the year, 2015, 14, where the firm, through the efforts of like Steve and Lisa and Pete and others, who they would describe it as hand-to-hand combat. Like, every day they were converting a new partner to think differently about how they serve their clients. And as an L&E firm, they did a fair amount of high-end, like big ticket work, bet the business type work. But much of the work was routine, single plaintiff employment litigation. It was, regular employment matters, advice and counsel on state by state regulatory and compliance challenges, and so on. Many L&E firms were facing the squeeze, and they got ahead of it by saying, look, we need to change our model if we're going to survive. So they were working with clients like DuPont and Motorola, who went like very deep in like hardcore Lean Six
They
Sigma,
invented
probably
it.
bank, right?
Yeah, they
And
invented it.
fast forward over a tough several years to convert the firm to think differently. They introduced like flavors of Lean Six Sigma over time. The Six Sigma math heavy, metrics heavy part of it little bit lightened and compressed. The lean part of it, like Toyota lean and so on, um, with the emphasis on leaning out processes that are not lean, right? They made huge headway on through introducing people with Lean Six Sigma, green belts and black belts, to process map everything, everything. And they started, as I recall, with internal processes, so looking at new business intake, conflict checks, and so on. And as they honed their skills, they started pulling in practices and looking at legal processes, particularly the ones that were under tremendous margin pressure. They would call it working with the willing, because if you're if you're losing money, you're pretty willing to try something new. And but then eventually included clients, and it became like probably the most critical piece of what they did was the collaborative way they approached it by bringing clients in with the client teams and finding ways to do business together. Now, naturally, that fits like really nicely at the high end, a little more difficult to scale out across routine work. But at the time I was consulting to the leadership team, they had 30, 35, maybe more individuals and roles that were labeled legal process improvement specialists, legal project managers. I think they had the biggest team of LPMs in the market at the time. We had tech and analytics and data experts. Many of these resources were held JDs. They just didn't practice. They shifted gears career-wise. And the question from the partnership was, can we do more with these resources? Can we organize them differently? Could we do anything with them? Like, so pretty broad stroke scan of the market and looking at scenarios in which these resources, these specialized resources, could be used in the best, highest value way. That led to, a desire to organize them into a single business, not just for observability into the business, but also to like better leverage each other to build multidisciplinary teams along with the lawyers, and to serve that to clients in a much more structured and at the time we were hoping more scalable way, like reach more clients, more partners with these resources. So that led to the creation of Sci-Fi Lean Consulting. The bones were there. I was the commercial guy who came in and helped sort of bring it together. Um, and then we went to market, and there was a lot of recognition for Sci-Fi at the time. So the conversations were excellent. Like client demand was very high. We had a lot of inbound interest. Can you come help us with imagine scenarios where we're asked to help with a panel consolidation project, and Sci-Fi, the firm, is on the panel. And this happened more than once, right? So that was might help you understand the separation part of it, right? But it wasn't without its challenges, and we set out to do at least an experiment of 1 year. Like, can we bring this as a business and as discrete products to market and see how far we could get?
So, yes, you've got a great perspective. I mean, you lived this, you know, scenario where you've got kind of a spin-off of a law firm. And, I wrote an article called Big Law 2.0, kind of a blueprint for the future, and proposed,
I read it. It's great. Yeah.
yeah, a model where you stand up, law firms stand up a C Corp, a standalone C Corp, not a subsidiary. I don't even know if legally that would work, having a C Corp subsidiary of a partnership. But anyway, a standalone subsidiary in the C Corp structure and the independent nature of being standalone, I think are very important aspects, because it allows a traditional, enterprise governance model to be applied, which doesn't exist in law firms. So, I spent years at Bank of America, as I mentioned earlier, mostly in risk management roles. I was in, so you have really four lines of defense in financial services. You have the line of business, so this could be consumer lending, or the investment bank, or the commercial bank, and you have controls within the line of business to mitigate risk. Then you have risk management partners. That's the second line of defense, that are aligned directly to these business units. Then the third layer of defense is internal audit. And I also worked in internal audit, where you would come in and evaluate the control environment and throw flags that would sometimes get escalated to an independent audit committee that reported directly to the board. And, they could get things done. A lot of people lost jobs over Sev 1 audit issues, especially if they were repeat offenders. And then the fourth line of defense is the Wall Street Journal. That's where you end up if the first three lines of defense fail. So we
Not a
jokingly,
good.
yeah, it's not a good day for a bank to end up in the Wall Street Journal for one of those issues. But yeah, that model doesn't exist in law firms, and it's a risk structure like that is very important amongst other structures, like having a shareholders elect a board that installs professional management and holds management accountable to goals and KPIs. And again, very different than the law firm partnership model and, the non-legal ownership. So you raised some really interesting points that I want to dig into. And you pointed to some past failures with models kind of like this. Atrium and Clearspire were a couple. And yeah, those did not succeed. I think Clearspire was early and their timing was bad for a couple reasons. One, it was like right in the middle of the Great Recession, which you could argue, what
Right?
better a
Yeah.
time to save clients money, but that's also a time where everybody's risk, shields are up, like you're trying to manage risk. And this was a risky new path. And then with Atrium, it's not going to be some 30-something tech bro who's going to come in and disrupt legal services. It's just not. Somebody like that with a big Silicon Valley war chest, I just don't see that happening. As I think, with no legal experience. Justin had no legal experience. He founded Twitch. So, what is your take on those scenarios and what we can learn from those past experiences to what might be coming next?
lot lot to unpack. Justin would say at the time that he was a power user of legal services and wasn't satisfied. Therefore, we need a new way of doing it. So I think it started from the right thinking. Um, Fast forward to today, we're seeing a lot of tech bro money come into the space. And sometimes that can come with a little bit of hubris, you know. I try to separate me being a cynical old timer in the space from, recognizing that we can learn from the past. I don't mean get anchored in the past, but, a lot of attempts like successful and failed have been made to change the model from inside and from outside, right? So Clearspire and Atrium are both really good examples. That was sort of a structural attempt to work around the model rules to allow for fee sharing and ownership and so on. So you have a tech company, and then you have the professional partnership, the law firm, the LLP, whatever, right? And they just come up with a relationship that, in my non-legal opinion, is skirting those rules just enough so that they can operate, right? I think you could make a good case that both those companies were ahead of their time
Totally.
because the premise makes sense to almost anyone, I think, right? Lower cost, better access to legal services. Like, and I'm, you know, excluding the consumer law access to justice side. Like, we're just talking like big business buying from big law, right? And, but they want better service at lower cost always, right? But I think in a nutshell, with both of them, the demand wasn't there to warrant the business. And it takes two to tango, right? I think one thing I learned, it was sort of ingrained in me at Cyparth, is that the voice of the client always wins, borrowing from the Lean Six Sigma terminology playbook,
VOC.
right? VOC wins. And if I needed to make a business case for any change, for anything, for any amount, for any resource, if I did not have the VOC with me, I wouldn't get it. So that's led me to this point of view that you not only should involve clients in the provisioning of legal service when you're talking about changing it, but it's necessary, right? Now, if you believe that, and the clients might be saying a lot about what they'd like to be different, how they'd like it to change. Um, but then the doing part isn't there, right? For example, we've been talking about AFAs and non-hourly billing for decades, right? We're still at, I don't know, I haven't studied this in a while, but like probably 20, 30% of AMLA work is subject to AFAs in some way at best. And it's going to vary
Best.
from practice firm to firm, right? Um, in my like experience being in the room, like observing this myself firsthand, even clients asking for non-hourly billing will almost always say, and give us shadow billing and give us your time records along with that. And you're like, well, wait a minute, like that's not how it works. And I think the work that cleanly fell into AFAs took sophistication on both sides, buy, sell, right? And the work needed to fit the pricing model. So again, like if you're a massive retailer with hundreds of thousands of employees, you're probably churning through thousands of small wage and hour issues and other things just year over year, month over month. So to sort of lump sum that into some volume arrangement, um, I wouldn't say it's easy, but it's a better fit because they look at it as a cost of business. It's no longer a legal service. It's a business service that has lawyers involved. Maybe, right? So not to get off track, but back to the attempts, like without the demand of the markets they served, and I'm a little more familiar with Atrium than Clearspire. Like Mark Cohen was early. And you're right. I think it was probably 2006, 7, 8, something like that. Um, Definitely ahead of his time. Probably spent a little more too fast on the tech platform side of things. But clients were, I'm going to guess, clients were pretty curious in the idea, but they weren't willing to just displace like entire swaths of legal work that was flowing out to incumbents, even if they're overspending, right? Um, because the credibility and the trust wasn't there yet. And that might be, to your point, what's shifting now is like, I think buyers are beginning to realize that some of this is somewhat mechanical. Like it can be delivered in ways that don't need a massive brand attached to it. But I still think that carries a lot of weight, right? With Atrium, though, they serve amongst others, they serve the startup market, like trying to get those early stage, like from seed to A, maybe to B. They're competing with the Wilsons and the Coolies and the others, Gundersons of the world. Um, Same thing. Like even those that invested in Atrium, um, I'm not sure they all signed up to be buyers of Atrium services, is my opinion. I have no special knowledge of it, right? So yeah, demand wasn't quite there. Justin, I think, went on record later saying, yeah, I'm a power user, but I was a little more interested in like the big thinking change than remembering to build a product that the market actually wanted, right? So after raising 75 million, um, invested in a lot of software, it just didn't work, right? And again, in my opinion, um, ignoring the past to some extent, sort of reinventing the wheel, and sort of ignoring the difficulty it is to have a relationship-based business, with lawyers with deep expertise, like pairing that with software and the mentality it takes to run a software business with the scale you get with it. Like those two are like, oil and water. So you got to find a way to like make those work. And that was one of the differences with Sci-Fi, to their credit, is that yes, subsidiary, but it wasn't designed to be like so removed from the firm. We were pretty integral with the firm. And if that wasn't there and we didn't have the brand like presence of Sci-Fi with us, nothing would have worked. Nothing would have worked. Right. So yeah, I think those are like unique attempts, similar structural model. Um, I think I said at one point somewhere along the way, they were a business by design, a law firm by regulation. Like
Mhm.
they wouldn't have had any law firm involved if they didn't need to. But that doesn't mean they wouldn't have lawyers involved, right? So they never figured that out, either of them. And I'd let Mark speak to Clearspire. That was a little bit before I paid very close attention to this stuff. It'd be a great guest, I think, too. But
You would.
yeah, I think both are very similar attempts, very different personalities and situations coming in. Did it pave the way for future efforts? I'm not sure.
Yeah. That's a really good question. Yeah, and Mark was an insider, right? He was an
Yeah,
attorney, and he's one of the, in my opinion, one of the great thought leaders in the space. I really
absolutely.
enjoy
Yeah, and
reading.
did it like talk about it, right? Yeah,
Exactly. Yeah. In fact, he hit me up on that article, the blueprint, and because I comment on his stuff, he wrote an article for Forbes. He's a Forbes author now, and it was I think it was called "The Enigma of Innovation in Big Law," and he made very good points. I've been beating on that drum for a while, and which would be a good segue into talking about that. So, law firms historically are one of the least innovative industries on the planet, and by a pretty big margin by my side. It's there. There's no real metrics on that. There are some proxies you can use, like tech investment would be one, but not all innovation is tech related. Some innovation is, your business model or your client engagement model or your internal firm compensation model. But all those things I just mentioned haven't changed at all in 40 years, right? 40 years ago is really when, well, shit, it's been 50 years now. The hourly, the billable hour really started to get traction, right? I mean, it's a concept from the 50s, but it didn't really get traction until the 70s. And we've been stuck in that silo for so very long, which, this is way before my time, but I've read the history on it. It was actually a partner at what is today Wilmer Hale, who proposed in it. It was to save clients money because a lot of work was being done on a flat fee basis then, and this was a more this provided more accountability to what the costs were to deliver the work
and visibility, right?
and
Like I think it was
visibility.
intended to sort of a breakdown of what we did for you, but it
Mhm.
was their only measure of value they could come up with, right?
Yeah. And it's not just them that suffer from it. All professional services in general. So I owned a consulting company for 14 years before I started Infodash. And man, we struggled too. Like firms would try and push us down, and we did business with only law firms. And it's so ironic that they would try and push us down the flat fee path. And really, they would always lead off with the does not exceeds. And I'm like, look, does not exceeds is a non-starter for, first of all, what it does not exceeds engagement is you bill me hourly up until you hit a point, and then you work for free until after scope is delivered. It's like, all right, you've taken away all the upside, right? It's only downside for me as the provider, right? If it's a flat fee, then at least if I'm efficient, I can have something in the bank to offset, the engagements where it doesn't go well.
Yeah. I mean, some of this is relatively basic economics, but I think it escapes not individuals. Like there are lots of smart people and innovative people in law firms, but the sum total of the model, legacy comp structure, the way the money flows, they're all pass through entities, right? Like the way all of that works just makes it very hard to actually do anything about it. But what do you do in a fixed price scenario? You can make it up in volume. It's a portfolio play. Like if I do 100 projects and I win some, I lose some. If I net okay, then okay, right? Or if it's like one large consulting project, but the client can't seem to lock in on scope, then how could you commit to a do not exceeds? And this is exactly what plays out in legal work. And some practice areas, some matter types are more easily boxed into a scope. Um, but if you can get the planets to align with that stuff, then the margin opportunity or challenge, depending on how you look at it, is in the hands of the firm. And if they can reduce their cost, but charge the same, they make more money. Like that's the simple economic part of it. Easier said than done. But sometimes I think especially with AI fueled automation and efficiency that's being touted right now, um, we can't forget that if we value the input of time, like that's how we get paid, and we reduce the time, like quite obviously that's not going to work. So You have to look at all four P's of product management when you're dealing with this. And product management as a discipline is not something a lot of firms have very deeply ingrained in their ethos. And but certainly there's a lot of pricing people who understand this. But pricing is one of those services, just kind of almost like innovation, that is very difficult to scale across all the partners, all the clients in the same way. Like, and I think that's one of the fundamental challenges of innovation in a firm is the scale side of it. Just like conversely, some of the biggest challenges the firm faces as an entity is scale if they want to grow, because you base it on hours. There are only so many hours, so many people. Like again, simple economics, right? But it's also the idea that not all, particularly with innovation, like not all partners, not all practices, and not even all clients are the same and warrant the same level of innovation investment, which creates a feeling of unfairness, and that freaks firms out. And partnerships, really start scrutinizing these things when they don't feel they're getting the share of innovation that others might be. And that's one of the biggest things I've seen in my advisory work with firms. I wrote an article a few years back where I talked about this concept of IPP, innovation per partner. And the idea is that, it touches on this scale issue, right? Like there's an imbalance between consumption of innovation and contribution to the pot that funds innovation. And if you ask all partners to spend on it, but they don't all feel the benefits coming from it, you're going to have a challenge, right?
That's a great point, and that's one of the reasons that I believe that the law firm partnership model, and I say that very intentionally. There are iterations, implementations of the partnership model that does scale, and accounting is, accounting and advisory is a good example of that. But the law firm partnership model does not scale, and which is why we have the AmLaw 200 and we have the Big Four in accounting, right? And the Big Four have almost twice as much revenue as the entire AmLaw 100, which is 140 billion for the AmLaw 100. It's about 240 billion for the Big Four, and some number north of 90% of all public companies use a Big Four firm for their audit work, right? So tremendous consolidation in that space. And so the number 5 accounting firm is Grant Thornton, and they're in the single digit billions. And last time I looked, it's been a while. My COO used to work there. And the smallest Big Four company is KPMG at 40 plus billion. That was last year's number. It's probably bigger now. So, and there's no R&D at law firms. They spend less than 1%. And I think that number is even generous on R&D. There is this emphasis placed on profit taking at the end of the year, which creates challenges. The not being able to give non-lawyers options to own a piece of the business is a challenge. Consensus-driven decision making, retirement horizons, the lateral mobility of lawyers to move from one firm to a next. Why am I going to invest in innovation in this firm when they may piss me off in 6 months and I take my business across the street to the competing firm? It's just too transient to really encourage long-term investment, and that has to get fixed. Otherwise, how are we going to? We can't just buy off the shelf tools to differentiate ourselves. That's by definition not
Race
differentiating.
to zero, right? Yeah.
Yeah. So like I see really fundamental challenges with the law firm partnership model on making the leap to what's coming next. How do you see it?
I I agree, of course, right? But I think I tend to look at the partnership model as like a necessary evil for a while longer. Like I
Yeah.
don't think we're going to easily see firms break that, right? Now, I just started reading an article earlier about accelerated de-equitization across firms. And I didn't dig into it enough to see the data, but I think it's a trend over the longer term. Yeah, we've seen more income partners, fewer equity partners. Like, so I think there is a shift toward the role of a partner as a stakeholder. And look, by and large, they've earned it. They've worked hard to get there. They put capital in, like they're an owner, right? So if we accept that, how do you work with that model to achieve the same benefits? Well, some of it is like the hand-to-hand combat we're talking about, right? It's hard to have a firm culture and strategy when each individual equity partner might have their own different opinion. But in firms that can all march the same, like to the beat of the same drum, so to speak. If you take, like even looking at the MLA 100, right? 150, 160 billion. I think average PBEP is about 3 million, right? Um, if you do the math, if you took 1 basis point, like not percentage point, of their annual average income, put that into a pool, you'd have a tub of money bigger than the legal tech fund, right?
Yeah.
So it's like, look, they can afford investment if they want. But the question is why, right? Like, well, why would we? If I'm making $3 million, again, am I going to make 3.1 as a result of this investment? What's my ROI? And it's a fair question, right? So, man, lots of opinions on how you come at innovation in those scenarios. Because if you don't, somebody eventually will come along and eat your lunch. But we've been saying that for a long time. Will AI change that? Maybe, right? Um, so I look at partners as shareholders, and they've earned the rewards and benefits that come with that. There are challenges certainly within that, but then partners are also managers usually.
Hmm.
Um, if you look at partners as investors in the way I was describing, even with the story at Sci-Par, like absolutely true that the equity partnership would be asking for, what is my ROI on all these investments, especially when they become pretty visible, like SLC, right? Um, and then the challenge for the innovator inside the firm is that the partners are also the primary customer of what they're doing. Like, so there's all these conflicting roles as a result of this model that
Hmm.
I think is not. If people were honest about what role they're in at what moment in time and based on what decisions they need to make, which is hard, then it'd be easier, right? Um, a good example, like an opposite example of this is that you saw that 650 Wilson's like subsidiary they sold to Paychex,
Yeah.
and we know how much. Like it was reported 70 million or 80 million or something like that. Um, uh, Wilson has about 250 equity partners, I think, out of 1,000 attorneys in the firm. Their PPEP is right at the average, about 3 million, right? So if you do the math there and you assume that they owned, say, half of the 650 business as a partnership, they grab another $150,000 each from that sale if it happened the way it was reported, right? Um, 150 relative to 3 billion is not a ton of money. I
Mm-mm.
mean, I would 150,000 extra, but um, so when you look at them wearing the investor hat, I think you got to play a different game, and that's how you make your business case as an innovator inside of a firm. Um, but the case I would make is like, look, do you want to design a future where you even sustain the level of income and success that you have today? Um, or do you want to be a victim of a future that is going to change how it all works around you? And like, so this proactive feeling I found is what drives more firms today because either new leadership, new market conditions, the combination of all of that is like making them think real hard about like, how do we fit into the legal ecosystem 5 years from now, 10 years from now? It's not like this future 50-year scenario that, it feels closer, whether it's accurate or not. And I think that's good. I think it drives the market toward substantive change. I think there's risk for firms like clients maybe figuring some of this out on their own and giving less work out to outside counsel, but that's another path to follow, right?
Yeah. Well, and so I think there's two things. The ROI is important, but there's also, have you heard of Coney? Cost of not investing, right? That's kind of
Yeah,
a,
yeah,
that is a very real number that is hard to quantify, but could have massive impact on the fundamentals of the business. And so
right,
much of like decision making, if it's rooted too much in kind of the here and now. ROI is mostly a here and now concept, right? When you say ROI, you're not typically thinking, oh yeah, I'm gonna acquire some learning that's going to benefit me 5 years from now. That's very intangible, and ROI tends to be very quantitative. So, much of what firms get by investing in R&D and this experimentation is learning. And it's one step in the journey to what's coming next, which is going to be a long path. And if you're not heading in the right direction, it's I think it's going to end badly for firms. Like, I see firms in the AM law, at the lower end of the AM law, especially, who are stuck in the mud, man. Like, their Gen AI strategy is they're doing a co-pilot implementation or POC in IT. And like, this is real, by the way. This is a real AM law firm that shall remain nameless. But had a conversation with them and just kind of asked what they were doing in the space, and just like, yeah, that's what we're doing. And I'm thinking to myself, you are not going to exist in definitely 10, maybe 5 years, unless you pivot so hard and start sprinting, which the culture just doesn't align to that. So it's like, yeah,
That's a,
man, the concept of Coney is real, and I think it's something firms should think about.
I think that's a real, I mean, that's a really important point, I think. A lot of, I've even done this, like it's easy to look at so-called innovation investments from some of these firms and just shrug them off and say, what are you doing? Like, how is that going to move the needle for anyone? But if we just called it something else, like marketing, would we be so judgmental? Would I? No. Um, if it, like to your point, an investment in learning, like future proofing, call it future proofing, right? Where we're not expecting a short-term result from this, but we're setting ourselves up to be better prepared for a long-term future and therefore judge it appropriately, right? And, if you're doing you're Kirkland doing what, not $9 billion, like to spend a few million here and there on experimental projects and stuff, like I think it's fair to call that R&D in some cases. I think it's
Yeah,
fair to call it investments in marketing. And as they say, like half my marketing is working. I don't know which one or whatever the old nugget is, but so yeah, like do you budget a certain amount of reinvestment back in the business, even as a partnership, where technically speaking, you are asking each individual part investor slash, i.e. partner, to pony out. Yeah, if most of them generally believe that these are good, sound investments, just costs, like no problem with that. Where I think it gets firms in trouble is when you get too far out ahead of your skis, you position yourselves as super innovative, but then those who would be receiving the benefits of said innovation are like, where are they? How come I'm not getting this? That's where the partnership model turns against itself. And I've seen it, and it's nasty. Like, so yeah, I think some of that is maybe comms. It's leadership. It's like a tough ask for the innovation and leadership of the firm in general to like really position, these are the investments we're making as an organization to move ourselves into the future. And again, easier said than done, but probably not said enough, I think, in
yeah.
my experience.
Yeah, I know you know Brad Blickstein. His group did their annual LDO survey, and last December, one of the questions was, my law firm partner or law firm partners are innovative. Almost 2/3 either strongly disagreed or disagreed, right? So 2/3, 63%. I still know the number because I did a presentation on it, and we've had almost a 2,000% increase in innovation investment within the last 10 years. Now 11. I did a little kind of survey of the ILTA roster. That's the main way. That is the big ticket investment item, is people. Today, that's gonna change over time. Well, we're almost out of time, and we got to touch on this one topic because this is why we came here, to talk about the Burford kind of MSO model that is interesting. And until the ABS rules either start to expand here in the U.S. or something else happens, like, you had some interesting thoughts about some of the challenges that that model presents based on your past experience. Like what are some of the hurdles that's standing up a managed services organization? And just so people know what the difference between like an MSO and an ALSP, I had to look this up because I really didn't know the difference. An ALSP is more kind of horizontal. It's an MSO is designed for when a client actually outsources an entire function. So it could be your maybe your intellectual property, your patent application process. You would do that in an MSO, where ALSPs are more kind of horizontal and task driven. That's at least what I was able to come up with. But what do you see as some of the challenges with that model going forward?
Yeah. Well, I think there is nuance in the difference between MSO, ALSP, and so on. But the bread and butter of it is like, well, what are they investing in, and what are they outsourcing, and what are they building? And look, I can see from Burford's standpoint, creating a new investment class for them, and this is what they do. Like they've created litigation as investment for people. Some firms participate in that. Some corporates participate in that, right? So when it comes to the MSO idea, if it's related at all to legal service, then yeah, they're skirting a lot of issues that have been skirted before, or at least we've tried. Um, but the way I can't help but look at it is from the partner's perspective in the firm. Even if there were a way to do that, then when you give up some of the upside of it, you give up some of the control of it, whatever it is. And in a firm big enough, now, and maybe this is down market, maybe there's some really interesting way to look at this that I haven't thought of, but I think for a big firm, like I was saying earlier, like there is capital to invest. They just need to choose to invest it. They can afford it. They, the partnership, the owners, right? Um, and I would think that most reasonable partners would want to look at several investment strategies, including those that don't involve giving up control or risking, brand reputation and anything else, right? Like, so what are they looking for? If the problem they're trying to solve together here is like, we need capital to invest in X, like I can think of 10 other ways to do that, including if we were to sort of break the regulatory hold on this stuff like the LSA did. Um, sure, like you could go get money from private equity if you wanted. There's a range of options. Today they go to the bank and they have
Yeah,
rotating lines and stuff, right? Like, so I just don't, I don't see it. Now, if it's more sort of non-essential paralegal or administrative functions in this MSO. Others have tried that too, including companies like Harbor or HBR or anyone like that, right, on the tech front.
yeah,
Um, so yeah, to be honest, like I've not studied it enough to have, a precise opinion, nor have I called and asked anyone. But I've seen this like desire to get money into the industry before. Investing in legal tech is one thing, and I do feel was a bit of a bubble ready to pop there, right? But investing in legal services directly, um, I would think those that provision the legal services would be the first to want to make that decision and decide if and when they need capital and why, and so on, whether it's tech related or not. I don't see Burford coming up with anything here, but
yeah.
or being interested outside of maybe some sort of consolidation of very small firms' interest in build. Like, could Burford help design a consortium of firms that
A
are
roll
working
up.
together? Like, quite possibly, right? And that would actually make sense in some ways to me.
What makes you say there's a bubble? Like Harvey had a 3 billion valuation, and then 4 months later it was 5 billion. Does that is
Well, you're absolutely
even Sam Altman is like saying people are going to lose a tremendous amount of money. And you know what? You're starting to see some investor shakiness. Like, I don't know if you followed, TR had like a 15% drop in one day.
mm,
Monday.com dropped at 30% in, I don't know, a 1 or 2 day period, because on an earnings call, they had talked about their SEO traction was slipping and didn't have good answers when they asked about implications to client acquisition cost, which they're very reliant on that channel for client acquisition. So when you start to see huge swings like that, that means investors are getting nervous, and all it's going to take is one match to light that fire, and then boom, we're going to end up in a correction.
I couldn't agree more. Yeah. Even though I'm somewhat on the receiving side of that.
Yeah, me too.
I think that's why the slow, steady, practical approach without over-investing could make sense for some, right? But inevitably, massive consolidation and carnage coming. That's my prediction.
A lot of fire sales.
Optimistic permission, prediction.
Well, this has been awesome, man. We didn't even get to half the things we were going to talk about, so I'll have to have you back on. But before we wrap up, man, how do people find out more about Lega, or find you on social media?
Yeah, thanks for asking. Lega.ai, go to our website, get the basics. Always happy to talk with anyone. I'm pretty active on LinkedIn, or try to be. And we had really good ILTA. I think you guys did too, right? Like, it was a great event this year. Some strong tailwinds. Like, I think I'm seeing a shift to more pragmatic approaches to thinking about Gen AI in practice. I'm seeing more people focus on literacy instead of throwing tools at people. I'm seeing plenty of fatigue from trying 50 products at the same time. So a lot of those things play in our favor, where we sort of focus on flexibility without provider and model and vendor lock, or even use case lock. Would like to say you are the use case. We're trying to enable people to figure out how to use this stuff before you scale this stuff, which implies spend a lot of money on this stuff. So I think the message is landing. Would love to talk to people about it, but obviously I'm always happy to talk about anything, clearly. so yeah, would love to come back on, talk more.
All right, good stuff. And we'll put links to your site and your LinkedIn profile in the show notes. But hey, man, it was a great conversation. I appreciate you spending a little time with me this afternoon.
Thanks, Ted. Enjoyed it.
All right.
Talk soon.
Take care. Thanks for listening to Legal Innovation Spotlight. If you found value in this chat, hit the subscribe button to be notified when we release new episodes. We'd also really appreciate it if you could take a moment to rate us and leave us a review wherever you're listening right now. Your feedback helps us provide you with top-notch content.